Lisa's there. It's good. You're good to go.
Thank you, Spencer. Good afternoon, all. My name is Lisa Kirshner, and I am the Public Access Ombudsman. Presenting today along with me is Sarah Clem, who is an Assistant Attorney General. She represents not only my program, but also the PIA Compliance Board. I'd like to underscore what Spencer just said about questions. We welcome them. They tend to make presentations much more useful to you if you have questions. I like to take them as we go, so long as time allows. So I would encourage you to put your questions in the chat when they occur to you. And if we don't get to your question today, you will please feel free to follow up with us afterward. The only caveat is please don't ask questions relating to any matter that is now in mediation or that you think may go to mediation through my office. Okay, I think we're ready to get going. Catherine, next slide. Okay. Here are the major topics we're going to cover today. As Spencer said, this has been a while in the making. I really want to specially acknowledge both Spencer and Catherine Bauer's work on this presentation today. They've done a tremendous amount of research and pairing and design work on it. So I thank both of them for all the work on this. Today we're going to cover the concept of personal information, what it is, the extent to which individual privacy interests are protected under the Public Information Act, as well as how those interests may be protected under other sources of law. Then we are going to talk a little bit about how, with things you can consider once you know you are dealing with personal information and or protected information relating to an individual. We'll talk about some techniques and approaches that may allow you to disclose at least some content or potentially content in a somewhat different form. And lastly, we'll leave you with some thoughts about resources you can use in the future. Next. Okay, and we can go to the next slide, I think is where we really jump in. In order to give you a context for our focus today, I'm going to try to blast through a series of slides that we usually use when we're doing what I call our PIA 101 training. So this is really intended just to give you some context. The Public Information Act, of course, is a statute. It was enacted by the Maryland General Assembly back in 1970, and it's found in the General Provisions article and encompasses the cited section. For those of you who may not have used the PIA manual in the past, you'll see there's a little icon in the lower right-hand corner of this slide. It is referring to Appendix E. E as in Edward, to the manual. Appendix E is the full text of the Public Information Act. It's a very convenient way to go read the verbatim text anytime you have a need to do that. And the manual itself is available online via the Attorney General's website. Next slide, please. Okay, so just to orient you to the kind of general purpose and basic provisions of the Act, the Act provides a means by which individuals as well as companies or organizations can obtain information via public records concerning government activities. Since it's a state law, we're really focused on state and local government entities. The Act provides two distinct rights. One is the right to inspect records on request. This would generally be a person coming into your office physically to inspect records, as well as the right to obtain copies of records on request. The right of access that is defined is broad. It does not limit the purpose or motive that has to be in play in order to require an agency or custodian to produce records. And even in cases, we'll see this as we work through today's slides, even in cases where there's some material that you may have to withhold or you may elect to withhold, the PIA always directs the custodian to produce that which can be produced, in which case we are in the realm of redactions. Okay, next slide, please. Sarah, let me just add, if you want to add to any of this, please hop in. Government collection of personal information and data. This slide is really just pointing out what I think we all know, and that is that state and local governments come into possession of all kinds of information about individuals in the course of performing their functions. So these are just, some common examples. Agencies have information about their employees. Regulatory agencies, licensing agencies have all kinds of information about their licensees. Different state and local entities have information about utilities and taxes and fines. Of course, school districts have lots of records relating to their students. There are various emergency numbers one can call in the 24 jurisdictions in Maryland, and there are records relating very frequently to those calls and responses. PIA requests themselves may identify information about individual, and the many public assistance programs that exist obviously will have information about their program users. The legislature has been concerned with providing some guidance and or direction as to what agencies can and can't do with this information when they acquire it, and at the same time, how this is to be balanced along with the goals of the Public Information Act. Go to the next slide. The first thing I'd like to point out is that, again, I think this is a fundamental. The Act, the Public Information Act, only applies to public records. If somebody asks for something that does not meet the definition of a public record, it is beyond the scope of the Act. The definition of a public record is quite broad. It includes any documentary material that is either made or received by the agency in connection with the transaction of public business in any form. This would include records in any format, in which they might exist in an agency's custody, any form in which they're maintained. There is the requirement that the record must have been either made or received in connection with official business. It does not encompass, this is to be distinguished from personal records, purely personal records. Next slide. And this slide is giving I guess, kind of foundational provision of the Act that states its purpose. In subpart A, its purpose is to provide a means of access to information about the affairs of government, as well as the official acts of officials and employees. And subpart B provides a rule of construction that may come into play in the context we're going to talk about today. And there is a caveat to this very broad right of access, and that is that unless an unwarranted invasion of the privacy of a person in interest, that also is a defined term, person in interest, would result. This title shall be construed in favor of allowing inspection of a public record with the least cost and least delay to the person or governmental unit that requests the inspection. So there is generally a tilt towards disclosure per 4103B, unless an unwarranted invasion of privacy of a person in interest would result. So this is a very early instance in which you can see the legislature taking note of individual privacy interests here with respect to persons in interest. Persons in interest are, by the way, are generally the person who is the subject of the record. There can be more than one person in interest in any given record. It's not an exclusive status necessarily, so it's something agency custodians will want to be mindful of. Next slide. We've talked a little bit about the presumption in favor of disclosure. And a very good rule of thumb that applies throughout the Act is unless you have a legal source of authority for withholding a record, either all of it or part of it, if it's in your custody and it is a public record, it must be disclosed. So the general rule is disclosure unless there is something that says otherwise. Another important kind of takeaway I want everybody to go away from here with is that although there are many exemptions in the Act in which the concept or even the terminology personal information is used, there is no global or omnibus kind of exemption that allows records either to be withheld or redacted to exclude personal information across the board. There is no such exception to the rule of disclosure that says thou shalt not produce personal information. There is no such thing in the Public Information Act. So to the extent personal information is protected, we're going to have to look at more detailed and specific provisions of law. Next slide. Public versus private. This is echoing the notion that the Public Information Act is intended as a means to reveal by which citizens can discover information about governance, about the official acts of agencies and officials. It is not intended to be a means to spy on your neighbor, per se, or to surveil personal activities of individuals. It has a public purpose that has to do with access to information about government. Okay, next. 4205 is the section of the Act that deals with access to records in a searchable and analyzable format. Now, this may seem commonplace today. In fact, I think it is pretty commonplace. But when enacted, when the PIA was enacted, it was far from commonplace. It may not even have existed in many agencies. So if a requester asks for records in a searchable and analyzable format, they are typically asking for data that may be maintained in a database that the agency has. And there are really three conditions. If a requester makes that request, the agency is obligated to produce the information if three conditions are satisfied. One, the request for it has been made. Two, the agency has it in that format. And three, the agency can disclose it in that format without also disclosing confidential or protected information. So we see right here off the bat, electronic records and data get produced when requested, assuming an agency has it, but not if you can't do so without compromising confidential or protected information. We'll talk a little bit more about later on about how ways that agencies can seek to protect that information while still disclosing what is allowable. Next slide, please. Personal information is another defined term in the Act, and it's defined by inclusion and exclusion. This section was recently amended to include all of the items, one small letter I through small letter A, and each of those items constitutes a piece of personal information. Personal information does not include, on the other hand, the four items listed under number 3. So again, it's just important to bear in mind that there is a definition, and if in doubt, you'll want to consult it. If it's relevant to what has to be done to respond to a request, you'll want to consult the definition. Next slide, please. Okay. We're going to go quickly through, and there are a number of provisions in the act that reflect that the legislature took some care to instruct agencies to limit the personal information that they collect and maintain about individuals. And prevention.
My name is Kendall Desonier. I had emailed you a couple of days ago asking about registering my.
Hello? I'm not sure what that, whether that related to us. I'm assuming not.
It was on hot mic. I took care of it.
Thank you. Yeah, so this is a direction that agencies and their various departments and officials should not be keeping information about individuals unless it's needed by the state or their unit in order to accomplish a purpose that is directed by law. And of course, this includes statutes, other types of legislative mandates, executive orders that come from the governor or a county executive or a mayor, or a judicial rule. And you have to need it to do your business. So by delineating these components, I think the legislature is really trying to send a message not to accumulate, not to ask for, and not to accumulate information about individuals that are not strictly needed to carry out a lawful required function. Okay.
Lisa, before we move on, it looks like there was a question in the chat that I think relates to the slide about electronic records. So the question is, if a record is downloaded as an Excel file, can you send it as a PDF file?
I mean, can you? I mean, if you're asking, will that fulfill your obligations under the act? It will if the requester accepts it as such. I mean, is an Excel file searchable and analyzable?
Yeah, I believe it is. Yes.
Okay. Yeah. So in that situation, I guess an Excel file would satisfy the literal definition. When I get technical questions along those lines, I either go to Spencer or Sarah, or I go to IT. But I am likely not to know the answer, whether a particular format has any set of capabilities. But so you shouldn't be afraid to do that when questions come up. Okay. Okay, are we on to the next slide? Thank you, Sarah. I appreciate your flagging that. Again, this is another section that is limiting the creation and maintenance of personal records. It has the same theme that agencies and officials should be mindful of what they're doing when they acquire personal information, and they should not either be creating, maintaining, or acquiring these items unless it's strictly needed. Strictly needed. Okay. I think some aspects of this are somewhat obvious. You certainly should not be obtaining them by fraud or any means that are illegal. Obviously, that would be a big no-no. Okay. Can we go on to the next slide? Okay. I mentioned at the outset that there is no global or omnibus exemption for personal information about an individual. There are, however, many specific exemptions. By the way, the term exemption, which as used in the Act, really refers to provisions that make certain types of records or information exempt from disclosure. They're exempt from that general rule of disclosure. So there are many specific provisions that deal with various types of records or various subject matters that agencies may have in their records that are going to be exempt. And many of these will refer to personal, will protect either personal information, or they will reflect and have provisions that protect the identity of individuals, thereby reflecting a concern that the privacy of individuals is protected. So this is a list of some very common mandatory exemptions that do protect the identity of individual records. And so for folks who work with the PIA, this comes as no surprise. One of the things that constantly surprises me is the number of exemptions that in one way or another reflect this sort of interest. So it's always a good idea to double check whether there are any such caveats or limitations in the Act. Some of these, I think, are very kind of self-evident why they would be protected, why privacy interests are implicated. Some of them also reflect security concerns, for example, the firearm and handgun records. The Act accommodates many other interests other than disclosure. Going back to the 2-column slide where the left side was personal information definition and right side was exceptions to those, what does personal information in vehicular accident reports mean? Do we not have to redact? Do we not have to redact from crash reports? We can leave that personal information. So there is a specific exemption that applies to MVA records, and I am not certain whether that exemption deals specifically with automobile crash reports or not. But it is a very lengthy exemption and with lots of very detailed provisions and then exceptions to the exception. So it's something you need to read very carefully. I can't answer that off the top of my head. I'll be happy to look into it and get back to you. Crash reports also can come within the realm of investigatory records if they're in the possession of a law enforcement agency, compiled for an investigative purpose. And that section does have carve-outs for different types of personal information or individual specific information. And last but not least, there may be some exceptions in other parts of the Maryland Code, not in the PIA, but in other parts of the code that allow for the provision of information about automobile accidents that can be provided, for example, to insurers, but that and groups that regulate insurers that cannot be made available to the public under the PIA. I can't quote chapter and verse to you on all those provisions, but I'd be happy to try to address that if you'll follow up with me after our presentation. Yes, a person can request their own personnel records and is entitled to see their own personnel records. I'd be interested in the answer to Mary Davison's question about PIA in accident reports too. If you, MS, will shoot me an email with your email address expressing your interest along with Mary Davison, we'll try to respond to you by email. Same goes for anyone else who's interested in that. You can do a me too by email. Yeah. I think, Sarah, have we gotten to all the questions in the chat there right now?
Yes.
I think so. Okay.
Mm-hmm.
Okay. By the way, never be afraid to, if somebody asks you or a requester is seeking a certain type of record, don't be afraid to tell somebody, I don't know the answer to that. I'm going to have to look it up. There are a number of different considerations we have to run through. I mean, I work with the PIA every day, and I will very frequently go back to the text of the statute and reread it in order to address a question. I mean, no matter how much you work with it, you just can't hold it all in your head. Okay, so we covered mandatory exemptions that apply to records that protect individual privacy interests. This is a list of sample mandatory exemptions that protect specific information that relates to privacy interests. So the point that I'm trying to get across here is not that anybody need memorize any of these. They are all in the statute, but that there are a lot of them. There are a lot of them, and you have to look to the specific section in order to verify what the precise scope of the protection is. They're not all the same. I found that people who tend certain groups of these exemptions tend to cluster around certain types of records, and so agencies will come to have an expertise in certain types of exemptions. But if you hit one you're not familiar with, it's always a good idea to go back and read the specific section. Okay, next slide, please. What I just said about mandatory exemptions also applies to discretionary exemptions. That is, there are some discretionary exemptions in the Act that they don't require, they allow you to redact certain information that relates to individuals. This is just an example of some of them. As if you didn't have a hard enough job as it is with discretionary exemptions. Okay. Any questions on this subject? Can electronic records, including body-worn camera footage, be provided to individuals asking for records of, say, their neighbor who was involved in a domestic dispute with their partner, where officers responded and recorded body-worn camera footage? I cannot answer that off the top of my head. What I would do is I would review that record, that video, that footage very carefully, and I would go to the text of 4351 and any other section that might be applicable. If there are minors involved or depicted in the footage, I would go to that exemption. If there's a depiction of a victim of physical violence, I would go to that exemption. If the depictions are such that medical information may be contained in the imagery, I would review the text of that exemption. So I do not think that this question can be answered generically. I think the answer is it depends. You have to review the footage closely. You have to then consult the potentially relevant exemptions. Sarah, did you want to add to that
I know there was, I don't think it was introduced this current session, but for the 3 or 4 past legislative sessions, there was a bill that would have made it so that body-worn camera footage depicting victims of certain crimes, and I think domestic violence crimes were included, would be subject to a mandatory exemption. So that would have created a mandatory redaction or withholding for that kind of footage, but it didn't pass. And so I think, as Lisa said, I think this would still fall under 4351, which is the discretionary exemption for investigative records. And, you would have to exercise your discretion there. And then, as Lisa mentioned, there could be some mandatory exemptions that apply, such as, medical information. If a police officer is asking, the victim about injuries or medical history, things like that, that probably couldn't be disclosed. But Lisa's absolutely right. I think that you'd have to take it on a case-by-case basis.
Okay. I'm going to introduce the next topic and then turn it over to Sarah. Okay, this is I'm not quite there yet. Section 4351 is very familiar to law enforcement agencies. I recommend that whenever 4351 is implicated, you read it very carefully. read it very carefully, because it has a number of parts, and what one part gives, the other takes away. So be careful in how you use that. Okay, next. We hit that slide. Next slide. Yeah, we can go on to the next slide. In addition to, by the way, in addition to information about investigations, this 4351 also protects or can potentially protect within an agency's discretion other kinds of information, such as security procedures or protocols, intelligence information. So it comes up quite often in the law enforcement setting. Okay, next. So this is the topic I'm going to be turning over to Sarah momentarily, and that is protections that exist outside of the PIA, of which there are many. The point that I want to make here is that Section 4301 of the PIA incorporates other sources of confidentiality protections, whether they be in federal law or in the other state statutes. So just because something isn't in the PIA doesn't mean it isn't protected. It may be protected if there's another statute that says it is. I see someone has asked may have asked a question about juvenile records. Did you see that?
Yeah, so it looks like there's a question adding on to the questions about body-worn camera footage, about if there is medical or information, or if it's about a juvenile, right, if you're going to be redacting or denying the entire footage. And I think, again, it depends on what exemption would apply. So the medical information exemption just applies to the information. It's the notion is that it's applicable to records that are disclosable, but might have information or parts of the record that can't be disclosed. So in that instance, I think you would be in redaction, in the area of redaction. The question about juveniles, I think, is a little different potentially, because the state statute, I think, protects records concerning a juvenile. And so, I mean, especially if it's a request where the identity of the juvenile is known, I think you would be denying the entire footage there. But it's hard to, as Lisa sort of said earlier, it's hard to have these kind of like blanket rules, I think. And I think, I mean, I know it's been onerous for especially like sort of small police departments who have lots and lots of body-worn camera footage. But you're going to be in a position where you're, I think, reviewing, for the most part, reviewing that footage to see what's disclosable and what's not.
Sarah, I think what you just said applies equally to the next question in the chat. I don't know if you had a chance to look at it, but it has to do with requests for body-worn camera footage or any footage really, but that depicts crime scenes or death scenes specifically. When the request is made for commercial purposes, essentially. I think, and the question is, are there other exemptions other than 4351 that can come into play? And I think the answer is yes, depends what the content is of the footage. And that's what needs to be reviewed very carefully and very specifically. Just as Sarah was explaining. Yeah, I wish I could make this issue easier for you. I really do. I wish I had a simple answer, but there just isn't a simple answer here. So I don't want to anyway mislead you. Okay, next is, I think so these are just some examples of when I say of a protection outside of the PIA. So for example, the Maryland Code contains provisions about the taxing authority, and it makes tax records of individuals confidential. Many people who work in education are very familiar with FERPA. It has myriad protections for information pertaining to students. And of course, HIPAA has very stringent protections pertaining to medical information in the hands of, typically in the hands of providers. So Sarah, do you want to kind of pick up with this this topic on?
Sure. And I guess
Okay.
I want to preface it with, we are going to sort of talk a little bit more specifically about some of these provisions, FERPA and HIPAA. We here in the public access unit obviously are not experts on those statutes, and they are very detailed. And so if you are working for an agency, that deals with us on a daily basis, you may already have much more in-depth knowledge of those. But if these do at some point come into play, you're going to want to make sure that you're looking at this, the source of the law itself, because they are, again, fairly detailed and specific. If you want to go to the next slide. I guess this just goes again back to the sort of the question about juvenile records. It's in the Courts and Judicial Proceedings article that makes a police record concerning a child confidential. And there's also a provision for court records as well, although courts are not subject to the PIA, so it probably doesn't come into play as much here. But there may be, law enforcement agencies that do have court records related to children and juveniles, and so those records would fall within this provision too. There is a question in the chat that says, would you generally say that who the requester is or whatever their motive may be should not be considered when processing a request? I think generally speaking, that is true. The PIA, there is a provision that says that the purpose of the request can't be a grounds for denial. There are, I think, some instances where obviously the identity of a person is relevant, right? Like if, to the question earlier about personnel records, if I'm requesting my own personnel records from the Office of the Attorney General, I have a right to see them, whereas the general public does not. Same for investigative records. Persons in interest have a greater right of access to those records, and there are only certain specific grounds under which a custodian can deny access. Generally speaking, whether the request is for a commercial purpose or research or some other purpose is not relevant to granting or denying the request. It may be relevant to whether or not you waive fees, if fees are involved and things like that. But I think so. In general, a sort of good rule of thumb is that shouldn't really matter in terms of the grant or denial. And then there's another question about, is a juvenile as an occupant of a car in an accident to be protected? So that's a good question. There's an OAG opinion that interprets the Courts and Judicial Proceedings provision to mean that police record concerning a child really is concerned with records that relate to like bringing the child within the jurisdiction of the juvenile court. So a juvenile as an occupant of a car in an accident that has nothing whatsoever to do with, the criminal laws or, allegations that the juvenile might be delinquent, I think wouldn't fall under the Courts and Judicial Proceedings article provision. And if you want to move on to the next slide. We pulled this one out. This is section 4330, the exemption for sociological information, because as Lisa has said a couple times, there is no global exemption for personal information. But this, I think, is as sort of close as the PIA gets to that sort of thing. This exemption is mandatory. It requires redaction of sociological information if the official custodian has adopted rules or regulations that define sociological information. And I know there are a lot of rules and regulations out there that, provide in their definitions, sort of cover what we might think of as personal information. So I think the next slide has the ombudsman's regulation, if you want to move to that. Yeah, so, personal mailing address, personal phone number, personal email address, date of birth, that is all information that could also be considered or is considered under the PIA personal information. And so it is sort of subsumed under this definition of sociological information. And I think, you can look in COMAR, a lot of different agencies have definitions that are very specific to the types of records that they keep and the sort of sensitive information, that might be found in those records. I know DPSCS's definition in COMAR is pretty lengthy and it covers a lot of ground. Next slide. And then this is one final other provision in the PIA. 4358 is covers temporary denial, so it allows a custodian to deny a request temporarily and then seek a court's permission to withhold information that's otherwise disclosable. So this is where, for instance, is where you have a request for a record and, the disclosure of the record or certain information in the record may causes the custodian to have concerns that disclosure would cause and it's substantial injury to the public interest. So if you have a record and there's nothing inside the PIA or outside of the PIA that would allow withholding, but you're concerned about releasing the information, you can issue a temporary denial, but then you need to petition the court within 10 working days to continue withholding that information. So there is work involved, and it's definitely if you would be working with counsel to invoke that exemption. You go to the next slide. Yeah, this is, like I said, the court would hold a hearing. The PIA requester can appear at that hearing and kind of make the case for why the information would be disclosed or should be disclosed.
Sarah, we have another question about juvenile records. We may want to cover before we go on, and then another one about does it matter how an agency requires the personal information?
Mm-hmm. So for juvenile records, if they committed an auto theft, would you redact or full out deny? Does it depend on who the requester is? So I'm gonna say you should definitely look at the statute before you make that determination. I mean, certainly an auto theft would be something that would potentially bring a juvenile into the jurisdiction of the courts. And the courts and judicial proceedings article refers to the whole record, the police record. So I don't, I think under that you would likely be, warranted in withholding the whole record. And I have to confess, I'm not sure whether that provision contains sort of a person in interest exception. Yeah. I mean, certainly if the juvenile has been, brought within the jurisdiction of the court, there will be discovery rules that would also apply, and, that they would get police records that way, potentially maybe even their parents would. That's I think a little beyond the scope of my knowledge to answer fully, unfortunately, unless, I don't know, Lisa, do you have?
I can't answer it definitively off the top of my head, but what I have encountered is that there are a lot of exceptions to the prohibition, and then there are exceptions to those exceptions. So this is one section, you just have to read it whenever you're working with it. There are provisions that would deny, let's say, a parent who may be the subject of an abuse or neglect of complaint that could result in a child coming before the juvenile court for example, in a child in need of assistance context, and in which the parent who would otherwise stand in the shoes of the child, and it would stand in the shoes of the person in interest, legally speaking, would deny that person access. So there are certain specific situations where Section 3.8, what is that? 8A27 of the Courts and Judicial Proceedings article denies a person in interest access to certain records about juveniles. They seem, from my recollection, they mainly seem geared toward protection of the child, as well as protection of people making complaints, depending on who that is. So it's something you have to read very carefully. That there are also provisions in that section that allows agencies to exercise their discretion in certain circumstances. For example, where there's a compelling need for disclosure of the record. So unfortunately, it's not something I can give a blanket answer to. I just can't give you a blanket answer. You have to read it really carefully and see where on the map you are. For the most part, though, juvenile records are pretty much off limits to everybody else, for sure. Sorry, Sarah, I didn't mean to.
No, there are a couple more questions. One is, does it matter where, how the PII was obtained? For example, given to us on a permit application versus taken from a person's driver's license by a police officer. I am not sure it matters, Lisa. I don't know if you have thoughts about that. I mean, it may.
Well, yeah. I think if you're talking about license, first of all, licensing, there is an exemption specific to licensing records that encompasses applications. And so the structure of that exemption is that you can only produce, it's kind of the reverse of the structure of the act itself. 4333 provides that an agency can produce, the following items. And if the item is not on that list, then it's not allowed to be produced subject to that mandatory exemption. To my recollection, I don't believe that I don't think that the license number is protected. I think there is information on a license application that can be disclosed, but perhaps not all of it. You have to go read the exemption, see what's allowed to be disclosed, what isn't. And then see, what was the other? Does it matter if it was taken from a person's driver's license by a police officer? Well, it could. It could if there's if a police officer is preparing, is obtaining the information in an official capacity or in connection with something that becomes an investigation, you may well want to be consulting 4351. Generally speaking, these exemptions, what can be released or not released depends on the content and function of the record itself. Yeah, in the hands of the MVA, a driver's license number is and license itself is not protected. Is protected. It's off limits. Correct, Sarah?
I believe
right?
so. Yeah, I believe that's right.
Yeah. So yes, it can. Yes, it can matter how you got it. Who sourced the record, and in what context it is prepared. The MVA exemption is another one that is quite lengthy and involved. So you need to see you need to see what personal information it exempts exactly.
Okay. I guess let's move on to the next slides, and then we can try to come back to some of the questions. So this is just a slide that is kind of emphasizing that a lot of these exemptions in the PIA for specific records or information are really concerned with individuals and not aggregate or anonymized data. So, it's a personnel record of an individual, a retirement record for an individual, school district record of a student, medical or psychological information about an individual, information about the finances of an individual. So if you have information that, it may be, financial information, but it's not tied to individuals at all, then it likely isn't going to fall under 4336. Same with personnel information. And we'll get to a slide in a little bit that shows sort of an example from a court case where that came up. If you want to go to the next slide. Catherine, okay, thanks. So yeah, so then that's again, this sort of implicates 4203, which governs denials and requires a custodian who denies a PI request to allow inspection of any part of the record that is subject to inspection. So, sometimes if your redaction of the personally identifying information would in fact allow disclosure of other parts of the record. Next slide, please. And this is the case I was just referring to. So in the Maryland Department of State Police versus the State Conference of NAACP branches, there was a PI request not for a specific officer's file or even a specific group of officers' files, but it was just for complaints of racial profiling against Maryland State Police troopers. And there are a lot of state police troopers throughout the state. At the time that this was decided, those records were considered personnel records, which are subject to mandatory denial. They're now considered investigatory records, subject to discretionary denial, but at the time they were personnel records. And MSP, in fact, denied the request and cited that exemption. But the Supreme Court of Maryland sort of observed that, after the names of the troopers, the complainants, and any identifying information was redacted, those records together, and again, there would have been, I think if there was a fairly large volume of complaints, unfortunately, and they ceased to be records about an individual or of an individual because you couldn't take the information that was disclosed and tie it back. So even though these complaints were quote unquote personnel records, there was a way for the custodian to remove the information about the individual so that the exemption no longer was implicated. Next slide, please. In addition to redaction, another potential tool may be aggregation, and you see this a lot with mandatory reporting for certain agencies, right? So there may be information that is protected, it's about individuals, sensitive information that can't be disclosed, but the aggregate information about many individuals can be. So one of the examples we have on here is the Ombudsman's program and mediation data. So the law does not permit the Ombudsman to disclose publicly specific information about individual mediations. She can't say so-and-so had a problem with this agency and this was the issue and here's what we did about it. But she can collect all of the information about mediations together and say, during this year we had 20 mediations involving this agency, and 50 of the disputes presented were this dispute. And it's the same for graduation rates and testing data, although that is subject to certain restraints, which we'll get to in a little bit. Health data, library checkout records, right? Libraries can't disclose the a single person's history of books that they've checked out, but they can say On the Road has been checked out 500 times this year, something like that. Next slide. All right, so this is getting into a little bit where, again, I just gonna stress that we are not experts by any means in practice. And I think Lisa may have things to add, I guess, just from her sort of general observations, more so than me, but an example of, a way to release certain information about individuals would be through de-identification. And basically it would be making it so that you can't connect the individual to the stored data that the agency might hold. So in the health field, you know, entities can provide information to other outlets like research institutions, but only, if that health information has been de-identified. And the Code of Federal Regulations actually has very specific outline of what what it means to be de-identified and how you can de-identify. So if obviously if you're in that field, you're going to be using that regulation. But it can also just sort of be helpful, I think, generally, to kind of think about like what is considered de-identified.
I would just kind of chime in with the thought that very often questions about de-identification will get into technical areas in terms of regarding electronic records, what can and can't be done readily. And I have found that there are any number of requesters who are very knowledgeable in this area and can often make very useful suggestions. But I will also often recommend that agency personnel check with your IT department on just what your capabilities are. They are going to vary depending upon the type of records you have and the size and capability of your agency. This is going to lead into, I think, pretty naturally another issue about what's with the creation of a new record versus producing existing records or data. But sometimes there are very, I guess the word would be feasible solutions through people with a little bit of knowledge about IT that will allow them to strip out fairly readily the protected information and yet produce useful information that's been requested. Sarah, did we have, I think, 3 questions? And do you want to,
Sure.
should we just run through those while they're
Yep.
somewhat fresh? Let's see, generally speaking, if access to a record is being denied on more than one basis, is advised that we respond with all of the bases for denial. So this would be a good place for me to mention that, we don't give, I don't give legal advice to people. And it's just important to understand that when I offer suggestions or ideas, they're just my idea. That's all they are. They're just my ideas or suggestions. So you will always want to consult counsel. If you are a counsel, you can bat these things around with colleagues and the like, or through my office. We're always happy to discuss. Generally speaking, I mean, the way I would approach something like this is if I felt there was more than one meritorious basis, and there's no reason that I can think of not to assert all the applicable bases, I would do it. On the other hand, I don't think I would necessarily kind of stretch, really stretch hard to get some tangential or merely theoretical basis incorporated into a denial, particularly if I have others that are much more clear cut. So I would judge that on a case by case basis, and I would try to make an assessment. Is this really an important basis for denying that I'm really relying on, or is it just, is it really more in the nature of an afterthought that I just happen to know about this? Okay. And then it says, is it possible for the next brown bag to focus on juveniles? Yes, anyone can submit requests. We'd love to have your ideas and requests for special topics. Absolutely. So please just send it, send us your thoughts and ideas on that topic. Was there anything else in the chat, Sarah?
Yeah, there is a question about, can someone request a copy of PI requests from an agency? And they certainly can. I mean, those PI requests are public records. They're records that an agency receives in connection with the transaction of its public business. So, whether they're disclosable or not, in whole or in part, you'd have to be looking at what the request contains and, and whether there are any exemptions that might apply, but definitely someone can request.
That's one, Sarah, that I've encountered where the concern that was expressed about producing them had to do with the fact that the request itself dealt with some topic that was sensitive. And there was concern that if the request, including identification of the requester, was released, that it could somehow result in, in some sort of harm coming to that individual, which is a serious concern. So what I wanted to flag for you is that with that type of concern and all others that aren't directly addressed by the PIA, if it is a really serious concern that you have, that you may well want to take a look at the temporary denial provisions, because it has been used in instances where there are those type of concerns. Something else you can consider is asking consent of the requester. I have encountered, and I know Sarah has too, instances where somebody's asked a request and it calls for disclosure of certain personal information as kind of part and parcel for the real thing that they're interested in. And there's some concern about releasing that sort of tag along personal information. And so I will frequently just suggest, just ask the person if they can live without this and explain what the concern is. And I have found that very often people are willing to forego that. They may not be, in which case you have to look to other potential remedies, but I wouldn't be afraid to ask if you have that kind of concern. I'm sure we can mastermind a PDF at some point.
Yeah.
Yeah, sure.
Yeah, and actually, Lisa, your response to the question about PI request just triggered in my mind. There is in 4351 in the section dealing with police misconduct records, there is a notice provision. A custodian has to let the officer know when the record is inspected, the misconduct record is inspected, but the custodian cannot disclose the identity of the requester. So in that instance, if you were to get a request for a PI request that's asking for misconduct records, you may be in a position to redact the name of the requester. Good
point. It's also a good illustration of why it's so important to go, no matter how much you know, go back and read the section. Go back and reread it.
Okay. I guess we can move on to the next slide from here. This is just sort of a reminder, or just to keep in mind, redaction, aggregation, and those sorts of tools don't always solve the problem, particularly when you're faced with a request for a specific individual's records, right? Like and this was what was at issue in the Glass versus Anne Arundel County case. The requester sought the IAD records of a specific police officer, and I guess floated the idea that they could just redact all of the personal information, but the court said no, we can't do that because the origin is obvious, right? The request states whose records these are. And so even if we redact all the personal information, the requester will still know that these are Officer Smith's IAD records. And I think, that's also reflected in one of the regulations addressing FERPA, right, with student records, right? Like the custodian, if they have reason to believe that the requester of a student record knows the identity of the student, then they can't disclose, even if it is, de-identified or, stripped of personally identifiable information. Go on to the next slide. So just another example of, a situation where redaction may not always work, even if you don't necessarily know who's the individual associated with a record or information. This came from an opinion of the Attorney General concerning dispatch records. So I think it was a newspaper wanted records that were generated after an ambulance was dispatched to a specific address on a specific date. And the newspaper suggested, well, you can just redact all of the identifying information and provide us with the medical information, right? Like with what happened to bring the ambulance there. And the AG said, well, you don't have to name or identify the individual precisely to fall within this exemption, right, for the medical or psychological information. Because even when a name or other directed identifiers are redacted, it may still be about an individual if the unredacted information sharply narrows the class of individuals to whom the medical information might apply. And so in that case, the AG said, this was a request directed at a specific address on a specific date. It may well be possible to figure out whose medical information that is, just based on that. And I guess to be clear, that the AG was not saying that the entire dispatch record could be withheld, but simply that the medical information in that record had to be redacted or should be redacted. Next. So then again, we come to FERPA, and FERPA deals with student records and has a particular definition for personally identifiable information. So it's things obviously like the student's name, the student's ID number, but it also defines personally identifiable information, and this is kind of in line with the AG's opinion, as other information that alone or in combination is linked or linkable to a specific student that would allow a reasonable person in the school community who does not have personal knowledge of the relevant circumstances to identify the student with reasonable certainty. And that's why you will see sometimes with data that's reported out by school systems that, even aggregated data isn't always reported because the size of the students that data applies to, like say, test scores for the third grade broken down by race. It may be that one of those categories has such a small number of students that it would be possible to kind of figure out who those students are and what their test scores were. Next slide. And same thing applies to potentially when the pool size is very large, right? So like if every student at a particular school is considered economically disadvantaged, you may not be able to disclose that fact because then you would know if a student goes to this school, right, that you would know their socioeconomic background. And just as a note, in Maryland, my understanding is the State Department of Education uses what they call a minimum N size. So it's the size of that pool of students to which that particular the data or the attributes apply of 10. And I know different states have different sizes. I mean, some of them have much bigger sizes, I think even going up to 25 or 26, but Maryland uses a fairly small pool size. And then again, that would just be the size at which they would not report out the data, right? So if the pool has 12 students in it, then they would report out the aggregated data, not the individual data, but the aggregated data. Next. And this again is just reiterating that standard under FERPA, right? It's a reasonable person in the school community. And it's specific to FERPA, but it's also something that you could maybe apply to medical information or, things of that nature as well. Next. So this brings us to, we're just talking about de-identifying data or aggregating data, which is sort of necessarily tied in with the idea of creating a new record. So the PIA does not require a custodian to create, compile, or program a new public record. So if you get a request for, for instance, like aggregated statistics, and you don't have a record where that's reflected, it may be that you would be creating or compiling a new record to answer that request, but maybe not. the standard, which I think is on the next slide, that the court of the appellate courts, actually this case went through both the appellate court and the Supreme Court of Maryland, kind of emphasize that it's a very fact-intensive process, right? Whether a request calls for the creation of a new record. And it depends on the structure and functionalities of the databases that an agency uses and the capabilities of the agency staff. So if the database allows staff to perform the extraction and sorting, and it's within their existing functionality and in the normal course, then it's unlikely that the request is going to be calling for creating a new record, right? So you have all of the data stored in a database, and what the request is really asking you to do is just pull certain of that data, and perhaps maybe sort it in a certain way. Then that's not a new record, right? That is just taking records you already have and providing them to the requester. Now, if you again, it's the existing functionality in the normal course, right? So this doesn't envision that you would have to go buy new software or hire a computer expert and things of that nature, right? Because that would not be in your existing functionality, most likely. Next. And this is again from the appellate court. The mere act of extracting, sorting, or formatting data that an agency collects and maintains in a database does not constitute creating a new record. So it may be that aggregating or de-identifying or formatting information and data may not then constitute creating a new record under that test. Next. But the court sort of observed that if the request asks the custodian to, generate new data or perform an analysis on existing data, beyond kind of sorting or, gathering it from disparate sources into one kind of new place, right? Like compiling, then that might be creating a new record. And again, I know it sounds a little bit mushy and nebulous, but it is really going to depend on the precise request, what they're seeking, and what your agency is capable of doing with the data that you have and the records that you have. Next slide.
I think of that one, Sarah, as the original research caveat. You're not required to do anyone's original research.
Right. It is important, though, to just stress that, you're not required to create new records, but the PIA also does not prohibit it. So there may be circumstances where it is actually easier and more efficient to respond to a PIA request in a way that is technically creating a new record. And if that's the case, you can absolutely do that. And, a custodian is not bound. The one time you choose to create a new record, it does not mean that going forward, every time you're going to have to do it. You can look at it on a case-by-case basis, but just keep in mind, right, that it's not a prohibition. It's just saying it's not something that's required. I think that might be the end. Next slide. Yeah.
We have one question in the chat, Sarah, that we didn't get to before.
Mm-hmm.
This was, let's see, this is going back to the juvenile records provisions that we reviewed earlier from the Courts and Judicial Proceedings article. Does it matter if a parent has full or partial legal or physical custody to obtain the child's record? So I assume that's asking a question in relation to that 38A27 section that comes out of the Courts and Judicial Proceedings article. And I don't know. I think I do not recall that it deals expressly with the custody issue, meaning it doesn't provide a blanket rule one way or the other. But I think it is a circumstance that can be considered, and it can be relevant depending upon the nature of the record and what the custodian might judge to be the risks in releasing it. So I think the answer is it can be relevant and it can be something that would be necessary to consider, but it may not be dispositive. I think it just depends.
Mhm.
I mean, all those the provisions relating to juveniles, as is the case with many other types of exemptions like this that are protecting individuals, it's concerned with protecting the interests of the juvenile. That's what the concern is that's driving it. So usually anything that's relevant to that conclusion will be, could be relevant.
Mhm.
Yeah. I hope that here we have another one. If a criminal incident report has a combination of juvenile and majority age suspects, would withholding or redacting and releasing be advised? Well, I mean, it seems, I'm just talking off the top of my head, honestly. I mean, as to the information as to the non-minor, that is the adult, obviously, I don't think any juvenile exemptions would not apply to that information. But anything concerning a juvenile would be subject to, you would have to review carefully all of the protections available to juveniles. By the way, the one example we pulled out that comes up under the Courts and Judicial Proceedings article, that is not the only protection in the law for juveniles. There are a lot of them. There are a lot of different ones. Some of them are in the health article or human services article, and it can come up in a lot of different contexts. But no, I wouldn't assume that everything's going to be redacted, including information about adults, just because the information relating to a juvenile has to be redacted. I wouldn't assume that.
Mhm.
What do you think, Sarah?
I think that's right.
Yeah, I've had instances of matters coming to me that involve where the person in interest as an adult was seeking his or her own records and could not get them because the agency interpreted the restriction as applying even to the person in interest. So this was not a 38A27 situation. It was a foster care situation in which there were other statutes that came into play. But some of these restrictions are really quite strict and literally require a court order. Well, even a subpoena won't do it. It has to be a court order. So
Right.
That's an area, very protected and regulated area talking about.
Yep. I think that's all we have.
I think so. Okay, this is a question about bank statements. Do they, as bank statements as a whole, get withheld, or do they need to be reviewed line by line to redact personal information and/or account numbers? Well, there are different exemptions that could come into play here. Certainly for individuals, an account that is owned by an individual, you would be looking to 4336, and generally all financial information of an individual is exempt, cannot be disclosed. That's a mandatory exemption. There's a kind of an analogous exemption that applies to business entities. That it works in a little different way, but when it applies and is invoked, it also is mandatory. But it protects confidential commercial information, including the financial information of businesses. So, Sarah, the test these days is whether the business entity would consider it generally as a practice discloses that type of information to the public or not. As far as
it's whether they customarily keep it confidential.
So probably the most likely a business does not post their bank statements to their website or some such disclosure. And seems likely that if not all of it, a good bit of it is going to be withheld. The financial particulars probably will be, the account number will be. So in the DPPA exception for organizations to get unredacted accident reports, how do we know if a company or organization is approved as a DPPA exception? So verification, I don't even know what DPPA is.
Unfortunately, I don't know that we can answer that question.
Yeah, I think that's something, if you want to talk about it, get in touch with us afterwards and we'll see if we can help you out with that. By the way, there were a number of questions asked today in the chat where the answer just can't be derived from the PIA. The PIA doesn't address it one way or the other. So in that instance, you need to satisfy yourself as to whether there's any other provision of law that controls. And if so, then and if it's mandatory, you have to follow that. And sometimes you'll encounter situations where there doesn't seem to be any law that governs it. And in which case, the answer is the answer isn't provided to you by the law. You have to use your best judgment. So those kinds of situations come up more often than you might think. Safety related support for insurance industry. Okay, that is interesting. Yeah, I don't know the answer to that question, but we will look into. I'm happy to look into it. Federal Drivers Privacy Protection. Okay. Thank you. Thank you for that. I don't know, but I will try to find out. The question is, how do you know if a particular company or organization is on that approved list? There's got to be a source. Could you develop a law enforcement centric presentation, or should we try to bring agencies together on our own? I think we can do both. I mean, yes, we can develop a training that's geared to law enforcement related topics and forming some kind of group of custodians who are regularly working in that area, or for requester groups who are involved in that area I think is a very good idea. That way you can share information and bad ideas around with similarly situated agencies. So yes, just shoot us an email and we will be happy to put it on our to-do list as one of the areas to cover.
Mary, you can go ahead and direct that email to me at Spencer. I'd be more than happy to talk with you a little bit more about that. We normally accommodate that kind of a request through kind of our private training channels, but certainly if we want to explore the idea of something more public like these brown bag lunch trainings, then that's an option. We'd be happy to have that conversation with you.
Yep. We have done trainings where, for example, law enforcement personnel from several neighboring counties may all be invited. And so we accommodate groups like that for trainings. We've done that. Resources and best practice. Question about resources and best practices for the ever expanding mandates within the PIA. Are you asking, is there a list of such resources, or to do a training on that? I'm not sure what it is true that there are so many detailed provisions in the Public Information Act that one frequently needs to consult other resources. great. People are offering to host trainings. That's great.
Yeah, Christine, I may end up taking you up on that offer, so thank you.
I would be more than happy to do that.
And so we are coming up on the 2 o'clock hour for us to conclude. And we know everybody has a busy day ahead of them, whether it's work or personal. So we want to respect that time. If for some reason we did miss something that you did place in the chat, I am downloading this chat and we will be looking at it after this training just to make sure that we didn't miss anything. But again, feel